What up, chat? It's been a bit. It's been a little bit. I mean, we haven't been here since Julio. Had to do this right, check on some things. The thumbnail was all fuzzy. So I'm like, let's get it. Let's get the clarity going. It's been a while. I need to make sure everybody could see us, right? And then StreamYard changed some things. They added a new feature where you can now vertical live stream, but I don't know if anybody watches that. And I didn't know how to use it and I ain't got time. So we're just gonna figure it out. They've got all these new features. Look at this. Look at this. Now we can put y'all's comments on the stream as we're going, right? So interesting stuff. Welcome back to another Power Hour. I am your host, AV. We are talking about the latest news from Tory Lanez, Megan Thee Stallion, that whole appeal. Hit the like button on your way in, okay? This is arguably one of the most divisive topics I've ever covered on my channel. And listen, we've had a few of them. All right. I think it was right around Christmas 2 years ago. Tory got, the jury came back in the case and Tory went to prison. Whoop-de-doo. Right. He appealed it. Okay. There was an appeals hearing that was televised. A lot of people talked about this like 2 months ago. Now, I just got my hands on a document fresh off the press, okay? Fresh off the press from the appeals court. I'm going to look at it. It's about 46 pages. And in this document, we're going to see how they came to their decision, right? And you have to be very careful with the terms here. How they came to their decision to keep his sentence as is. That's what it is. We'll talk about what Tory's options are. Again, it has been very divisive back in the day because you have people that are pro Megan, where they're like, he shot her. And there are people that are like pro Tory, like, hey, what about the friend? Are we gonna look at the friend? The friend that was pleading the fifth on the stand? A lot going on, right? Taz says, I was in Cape Verde watching tweets. It was crazy, right? So we're going to look at the document. This is going to be a quick little stream. It was super last minute. Also just going to give you guys some updates because number one, last week, the OnlyFans model, Courtney Clenny, was supposed to show up in court on November 5th. Here's what happened. This is why we didn't go live. It was postponed to December 5th. Okay. So December 5th is a pretty big hearing in her case. Next up, I spent some time on the phone with Alicia's attorney, and I'm not talking about Jeremy. Wait until y'all find out. Wait. Oh my God. I can't wait to tell y'all. Wait until y'all find out what's going on with that. Ironically, speaking of Jeremy, Megan Thee Stallion's actually going to be in court next week in Miami with her I think it's a defamation case with Milagros. That starts next week. It's federal, not televised. Thank you, free speech. We should be able to see all of that. But guess who's representing Milagros? Jeremy. That's it, Taz. Taz already knows. Jeremy is representing Milagros. So more on that later. In other news, ASAP Rocky, okay? We're still going to trial on January 12th. Here's what's going on with that case. Really drop the charges against ASAP Rocky. He just did it. It's done. He's just going after Takapina. So you know that's going to take us 2 days to cover. We're just doing that. There's so much tea here, guys. What the hell's going on with Antonio Brown? Did y'all see the mug shots? He went to Dubai and he got caught. Freaking Akon was arrested over the weekend too. Everybody just going to jail. We all going to prison. I'm like, I can't keep up. There's so much going on. And then everybody's like, hey, V, we haven't seen you in a long time. I said, do you know how much legal news me and my team are researching right now? How many videos we're trying to produce? Everybody's just going to prison. YNW's friend is snitching. I still got to look at that interrogation video. There's so much stuff going on, guys. And then y'all are telling me about this crazy woman named Latoshia. We might have to do that trial on Saturday. We might just have to watch the whole joint because I heard it was crazy. So we are here. All right. We are here. There's so much going on. So we covered, Fonnie. I had to do a plan B and a plan A plan for Fonnie. We had to put a video out today. I just recorded it. I edited that one myself because we don't know if Annie's supposed to show up in court tomorrow. She's supposed to show, not court, she's supposed to show up in front of the Georgia Senate Committee. Okay. Like she said she was going to show up. Her attorney said she was going to show up. Then I'm hearing reports from reporters that are on the ground in Atlanta saying, hey, there's rumors that she has a scheduling conflict and she's not going to make it again. So we have all of that. So she may or may not show up tomorrow. The more important thing is that the deadline to remove that case to a new prosecution's office is on Friday. So that is why I'm trying to keep everything open right now, because that is going to be huge. Aside from YSL, Fonnie bought the RICO charges against, Trump and team, right? So we're going to see what's going on with that. And then everybody's like, hey, did you see what's going on with Epstein? I said, this is a crazy week. So anyway, let's get to the Tory and Meghan thing. 46 pages. We're going to get through it fairly quickly, and then everybody's going to go have din, and we will be back here tomorrow. And then I even tell y'all about Nathan Wade, but we ain't got time, child. We don't have time for Nathan today. Let us look at this. And they've changed so many things back here. Give me my banner back. Thank you. All right, here we go. And I'm going to take y'all's comments down off for a second, but I did want to show you that now for those that are watching from the TV and from the phone, that we can do that moving forward. This came out today, a few hours ago. It does say that it's not officially published yet. So this is hot off of the press, okay? California has specific rules where they make these documents super official. So we're not super official, yes, but this is, I'm going to call us 95%. This is the People versus Daystar Peterson. All right, this is the appeal from a judgment of the Superior Court of LA County, and it has been affirmed. All right, talks about all the people that are involved, all the attorneys, the Baez law firm. You have Rob Bonta, the Attorney General. A lot of people have been involved in this particular case. All right, let's go. Here's your narrative. In December of 2022, a jury convicted Daystar Peterson of assault with a semi-automatic firearm on Megan Pete, carrying a concealed unregistered firearm in a vehicle, and discharging a firearm with gross negligence. The court sentenced Peterson to 10 years in state prison. On appeal, Peterson contends the trial court committed a number of errors. Here it is, chat. We find no prejudicial error and accordingly affirm his conviction. Well, damn. Just the first couple sentences, we're already there. They're like, what are you talking about? We don't see anything. No prejudicial error and accordingly affirm Peterson's conviction. And here's the thing, with Tory Lanez, I wish that would have been one of the trials that was televised that we can see. But, unfortunately, it was one of those that was in federal court and we weren't able to see what was going on, right? So, it's tough when you can't see what happened in there, right? But let's keep going to see what they have for facts and procedural background. Peterson fires 5 shots at Megan, striking her in the feet. On July 12th of 2020, Pete went to a gathering at Kylie Jenner's house. At some point, Pete texted Peterson and told him to come. When Peterson arrived, it was really late. Eventually, Pete wanted to leave. Pete, her friend and personal assistant, Kelsey, there it is, it's Kelsey, and Peterson got into an SUV driven by Peterson's driver, Jaquan Smith. An argument started about the relationship among Pete, Harris, and Peterson. Pete asked to be let out of the SUV. Pete got out and started walking away. She heard Peterson say, "Dance, itch!" Pete turned her head a little bit and saw Peterson pointing a gun at her. She froze. Pete heard shots. She looked down at her feet and saw all the blood. Pete dropped to the ground, crawled into a driveway. Pete felt pain in both of her feet. After that, it got blurry. Pete saw Peterson and Harris walking towards her. Peterson started apologizing. Pete got back into the SUV. They heard police sirens, and Peterson told Pete and Harris, "Please, y'all, don't say anything. I'm about to sign a big deal. I'll give both of you $1 million each." At 4:27 a.m., Harris sent a text to a Justin Edison, who handled Pete's security. The text said, "Help! Tory shot Meg, 911. There's a footnote. What does that footnote say down bottom? It says Peterson, a rap artist, performed as Tory Lanez. The record reflects friends also call him Tory. All right, let's keep going. Police stopped the SUV. They asked everyone to get out. Pete told the police she stepped on glass. So here, Meg wasn't truthful at first. She didn't tell them she'd been shot. When asked at trial why she told the police she stepped on glass, Meg referred to the then recent murder of George Floyd. I've seen some rambling about this. Pete testified she didn't know if they're going to shoot first and ask questions later. And she didn't feel safe with police officers. Now, this was back in 2020. Makes sense. When did George Floyd die, y'all? Like, what was the date? Date of death, George Floyd. May 25th, 2020. And this incident took place in July. So it was fresh. I think it's valid. I mean, do I agree? No, but it would be on people's minds. Let's keep going. And again, last time I covered this, a lot of new people come in. I'm literally reading the same thing that you're reading, okay? So this is not a divisive channel where we pick sides, right? We're looking at legal documents. So join me in that, huh? Mods are here. The mods are here. So please know I got bouncers in this joint that will kick you out. Let's keep going. Pete testified she didn't know if they were going to shoot first and ask questions later, and she didn't feel safe with the police officers. Officers found a 9mm Luger semi-automatic handgun on the floorboard of the front passenger seat. The gun was in the side lock position, meaning all the rounds had been fired from the magazine. Important for us to know. It was warm to the touch, even though it was cold outside at that hour of the morning. Officers also found a bloody towel in the back seat. The officers took Peterson, Harris, and Smith into custody. So everybody got arrested. At the stations, officers checked the hands of all three for gunshot residue. The samples taken from Peterson and Harris were positive for gunshot residue. So that means the friend, Kelsey, and that means Tory, their hands were, the samples taken from their hands were positive for GSR. A criminalist testified at trial that if Harris had been standing within feet of an individual firing a firearm and came into contact with that individual after he fired a firearm, she would be surprised if Harris tested positive for gunshot residue. No gunshot residue particles were detected on the sample taken from Smith. An ambulance took Pete to the hospital. Neither in the ambulance nor at the hospital did Pete tell the medical providers that she had been shot. Everybody is assuming that Meg stepped on glass. She later explained, in the Black community, it's not really acceptable to be cooperating with police officers. Pete also said that when a woman accuses a man of something, people have a hard time believing you. She added this whole situation in the industry like a big boys club. This whole situation in the industry like a big boys club. Like I'm telling all of y'all's friends and now everybody about to hate me. Around 9:05 in the morning of the shooting, Peterson called Harris from jail. A recording of the call was played for the jury. Harrison told Peterson that Pete was still in the hospital and she was waiting outside. Peterson says, I know she probably never ever gonna talk to me again, but bruh, I just want you to know, bruh, ninjas, I was just so effing drunk. I never do some shit like that, bruh. You know, regardless, that's not gonna make anything right. And that's not gonna make my actions right, bro. But I'm deeply sorry, bruh. So like I feel crazy, bruh. But a mistake like what happened already, bruh. I can't take it back, bruh. I'm just telling y'all. I'm sorry, bruh. At 8:59 p.m. that evening, Peterson texted Pete. The text said, Meg, I know you probably never gonna talk to me again, but I genuinely want you to know I'm sorry from the bottom of my heart. And I was just too drunk. Nonetheless, shit should have never happened, and I can't change what I did. I just feel horrible because I genuinely just got too drunk. I love you, and I hope you're okay. Peterson sent Pete other text messages just apologizing. Pete had bullet fragments in both of her feet. She had to have surgery and physical therapy. Pete couldn't walk for a while. She can't really feel the left side of her foot. About 4 days after the shooting, Pete told police who shot her. Pete testified she had a change of heart because Peterson had tried to start getting ahead of the story online. He put on a bunch of different narratives about what happened. Now, this is where people start to get a little frustrated with Meg because Meg talked to the police and said that it was glass, right? Then the online stuff happens and then change of heart. Now the truth comes out a few days later. So in these online beefs, so to speak, when people are like out there on the free Tory side or they're on the Meg side, the free Tory people, I will say that they were like, hey, why did she lie in the first place? Why did the stories change? Okay. Now let's keep going. DNA testing of the Luger revealed a profile of at least 4 people. Peterson could not be excluded or included, right? Free Tory people like that sentence there. His contribution was inconclusive. DNA testing of the magazine also revealed a profile of at least 4 people. Peterson was not one of them. See this? This is where you have a problem with some of the evidence. No usable fingerprints were found on the gun or the magazine. In response to the prosecutor's questions at trial, Pete testified she was having a really difficult time sitting up there and trying to comfortably tell her story, apparently referring to spectators in the courtroom. Pete said a group of people had been continuously spreading misinformation to make her look like a bad person. The charges, the trial, the verdicts. The people charged Peterson with assault with a semi-automatic firearm on Pete for count 1, having a concealed firearm not registered to him in a vehicle, count 2, and a discharge of a firearm with gross negligence, count 3. In count 1, the people alleged Peterson personally used a firearm. In counts 1 and 3, the people alleged Peterson personally inflicted great bodily injury on Meg. The people also allege aggravating factors under the California rules of court. The case went to trial in December of 2022. Among other witnesses, the defense called Sean Kelly. Kelly testified he lived near Nichols Canyon. And in July 2020, Kelly was asleep. He was awoken by lots of shouting and voices. He looked through his window and saw two girls arguing. This is your eyewitness, okay? Then they started fighting. They were pulling their hair and hitting each other. It was quite violent. A tall man got out of the driver's side of the car and got involved in the fighting. One of the girls went to the car. Kelly then heard what at first he thought were fireworks. He saw a muzzle flash. It reminds us of YSL, muzzle flash. At about the same time, a smaller gentleman got out of the back passenger seat. He was shouting a lot. Kelly saw more flashes and what was obviously gunfire. The muzzle flash was near the girls. Kelly did not hear anyone say, "Dance, itch," although both defense counsel's questions and Kelly's answers were unclear. Kelly seemed to say, "The girl who was the aggressor went to the car and he saw the muzzle flashes coming from her hand." Now, see, that's the other gripe people have. Was it Kelsey? But this is the eyewitness, right? So, usually on appeals, things that happened during the trial that we were all not able to watch come up on appeal, and you look at some of the procedural issues that might have happened during the trial. Did the judge make an unjust ruling? Did a defense attorney say something? Did the prosecution say something that could warrant an appeal, right? Let's keep going and see, because remember, this is the appeals court writing this narrative up top, all right? We haven't even gotten into the legal arguments yet. And yes, Kelsey did plead the fifth on the stand. Okay. Kelly seemed to say the girl who was the aggressor went to the car and he saw muzzle flashes coming from her hand. Kelly then said the flashes came from the shorter man. Now, there's two footnotes here that we're going to read as well. It says, about 2 weeks into the trial, near the end of the people's case, the prosecution moved to add 2 more felony counts to the information for dissuading 2 witnesses, Pete and Harris, under Section 136(1). The court denied the motion. References to the statute are to the penal code unless otherwise noted. Counsel didn't ask Kelly about the precise date, referring only to an incident that took place in July of 2020. So technicality, but we have that. Kelly testified, "I believe I saw the girl shoot first. They were both shooting." Kelly never saw a gun. He called 911. On cross-examination, Kelly admitted he told investigators that the short guy came out of the car and then he shot the girl. Then the girl fell onto the road and started bleeding. When asked what was he saying at that time, Kelly replied, "A torrent of abuse. It was just all N-words. And F motherfucker." Oh, shoot. I tried to conceal that, but I said it. "Sorry, mother effer." And also admitted he'd never mentioned a girl involved in the shooting to the 911 operator, nor did he mention a female shooter to the responding officer. So that's a problem. You're the eyewitness. You're saying that you saw a woman as a shooter. You didn't tell the cops and you didn't tell 911. So you're starting to see how these narratives have issues with them, right? Let's keep going, because this is the eyewitness. If that is what he saw, he should have been clear the entire time. But people make mistakes, Let's keep going to see what else they say here. Peterson chose not to testify. The jury convicted Peterson on all 3 counts and found the firearm and great bodily injury allegations true. Peterson, represented by new counsel, filed a motion for a new trial. The court conducted a lengthy hearing on the motion over several days. The court ultimately denied the motion. The court conducted a bench trial on the factors in aggravation under the California Rules of Court. The court found true aggravating factors that Peterson used a weapon in the commission of the crime, and the victim was particularly vulnerable. The court also found that Peterson's conduct toward the victim after the incident to be an aggravated factor. The court listed social media posts, releasing songs with lyrics directed towards the victim, attempts to dissuade or perhaps give money to her and the other witness, violating the protective order. So another footnote here. It says references to the rules or to the California rules of court at the beginning of trial. Peterson agreed to bifurcate the trial on the factors in aggravation and to waive jury on those allegations. The court also stated, I think this is a very significant aggravating factor in this case. The court added there were 2 times that he violated the protective order where the court had to step in and raise his bail. The court found not true the prosecution's allegation that the crime involved a high degree of cruelty, viciousness, or callousness within the meaning of the rule. Very long footnote here. Let's look at this one. This is footnote 5. It says the trial court increased Peterson's bail several times between his arraignment in November of 2020 and trial in December of 2022. So he was in jail for almost 2 years. In August of 21, the court granted the prosecution's motion to increase bail. As a condition of bail at the new higher amount, the court ordered Peterson not to attend or appear at events where Megan is scheduled to appear. In April of 2022, the parties again appeared before the court to discuss another motion the prosecution had filed to increase bail. The prosecutor referred to a music video where he's depicting violent imagery coupled with lookalikes in the video of Meg and her boyfriend. This apparently was a reference to a music video Pete mentioned in her testimony at trial showing Peterson chopping up horse legs. Wow. Based on the exhibits of the prosecution presented, the court found Peterson in violation of both the protective order and the discovery order. As a condition of bail at a new higher amount, the court told Peterson, sir, you are not to mention Meg in this case or anything about this case in any social media or public statements, either directly or indirectly. In October of 2022, the parties appeared before the court yet again on the prosecution's motion to set bail at no bail. The court denied that motion but ordered electronic monitoring of house arrest for Peterson pending trial. The record on appeal includes reporters and clerks' transcripts of the bail proceedings, but not the motions, opposition briefs, or exhibits filed in connection with them. The court also found 3 mitigating factors: that Peterson had no prior record, so Tory had no record of criminal conduct, that he had actively participated in charitable or philanthropic causes, and that he did not pose a significant risk of reoffending in a violent manner. Before pronouncing sentence, the court heard from 7 witnesses called by Tory. The court also listed the authors of 76 letters it had received from Tory's supporters. A prosecutor read aloud a letter written by Meg as a victim impact statement. The prosecution asked the court to sentence Tory to 13 years in a state prison. The court sentenced Tory to 10. The court found the aggravated and mitigating circumstances were a wash. The court selected the midterm of 6 years on count 1, assault with a semi-automatic firearm. The court also chose a midterm of 4 years for the firearm enhancement. On count 2, carrying a concealed, unregistered firearm in a vehicle, the court sentenced Peterson to a midterm of 2 years to be served concurrently with count 1. The court stayed under section 654, the sentence on count 3, discharge of a firearm with gross negligence. As to counts 1 and 3, the court dismissed with great bodily injury enhancement under section 1385, subdivision C2, presumably in accordance with the Senate Bill number 81. All right, that is the narrative. Okay. And remember, this is coming from the appeals court in California. It is a panel of people. They're reviewing the case, and now they're going to get into their discussion. So this is going to be some of the legal issues that Tory's team had raised up on appeal. We're going to see why they affirmed their decision to keep his sentence at 10 years and why they disagreed that there were problems in the case. So we're going to look at all of that real quick. Let me take a look at some supers. I think we only have two of them, both from the same person. Shout out to Deonra. Gifted a AV membership. If you receive that membership, please say thank you. Few people sending me cash apps. Shout out to E Capone sending me a 7. Thank you so much, E Capone. It's good to see you. And also, I saw you in the comment section on the other video that we dropped earlier today. So I appreciate that. D with the 2 says, you got to love the ratchetness of this case. You know, that's what, well, you know, here's the thing. I really wanted to see this one. I really wanted to see this one. I wanted to look at the witnesses on the stand, see the attorneys duke it out, see what the judge was like, all of that. It would have been great to see this one. But because it was done in a federal manner, there were no cameras. And in some cases, the judge will have discretion on whether they want to let the media in. And I do remember a lot of people. I think I had somebody boots on the ground back then that was calling us and calling into our shows and letting us know what was going on with Megan and Tory during that trial. I can't remember his name, but I could see it. The thing is, though, me and Lead were covering some of the first YSL hearings on the same day. And that's why we couldn't do both at the same time. But it's very interesting. And thank you so much, D. Okay. Let's see what their discussion is. Thank you, Young Money, state, not federal, but I corrected myself when I said there are some, those are usually the options of when there's not cameras in the room. One, high profile nature. If it's state, the judge has this discretion, they could say no. The other option is if it's a federal case. So with Diddy, we did not see that. So shout out to Free Thugga. Dirk is coming up. We will not have cameras in that courtroom. That's in January, right? Thank you guys for loving the frames. These are new. Shout out to Tom 40. All right, let's go back into the discussion because this is the most important part of this document. And that's where these judges really talk about the conclusions they came to. So the first one, the trial court did not abuse its discretion in permitting the prosecutor to ask Pete questions. So asking Meg questions directed to her, inconsistent reports to police, and her attitude about the case and about testifying. Well, that is interesting. The trial court did not make a mistake in permitting the prosecutor to ask Meg questions directed to her, inconsistent reports to police, and her attitude about the case and about testifying. So that was one of Tory's things. He's just like, okay, did you guys ask Meg questions about when she lied to the police? And the judge, permitted some things here. Let's just see what they say. Peterson contends the trial court abused its discretion in allowing testimony and evidence concerning Pete's emotions about the incident and its aftermath. On direct examination, the prosecutor asked Pete questions about her initial statements to law enforcement and medical personnel that she cut her feet on glass. Pete responded that when a woman says a man did something to her, people have a hard time believing you. Pete said she never wanted to come forward. I didn't want to say nothing in the first place. Defense counsel objected to 9 questions along those lines. The court overruled 5 of the objections and sustained 4. In cross-examination, Tory's team repeatedly asked Pete if she lied. Question. You also on CBS were asked a couple times if you had some type of sexual relationship with my client, correct? Meg, yes. And you lied, correct? Meg, yes. You lied on national TV, correct? Meg, yes. You also lied to the prosecutors, correct? Meg, yes. You also lied to Detective Stongner about this issue, about the relationship, correct? Meg, yes. On redirect, the prosecutor asked Meg questions that were follow-ups to areas defense counsel had raised. Pete testified people had been making things up and putting out different stories that weren't true, saying that I had never been shot at all. So Meg continued, I had to come out and say, yes, I was shot. I didn't just step on glass. I should have told the truth initially. I know that now. And I thought I was trying to protect people. I thought I was doing the right thing. I thought I was protecting myself. But in the long run, I wasn't. Relevant evidence is evidence having any tendency in reason to prove or disprove any disputed fact that is of consequence to the determination of the action. Even if evidence is relevant, Evidence Code Section 352 gives the trial court discretion to exclude if its probative value is substantially outweighed by the probability of that its admission will create a substantial danger of undue prejudice. The prejudice that exclusion of evidence under Section 352 is designed to avoid is not the prejudice or damage to a defense that naturally flows from relevant, highly probative evidence. The prejudice that Section 352 refers to is evidence that uniquely tends to evoke an emotional bias against the defendant as an individual, and that has very little effect on the issues. In general, the trial court has vested with wide discretion in determining relevance and weighing the prejudicial effect of proffered evidence against its probative value. Its rulings will not be overturned on appeal absent an abuse of that discretion. A trial court abuses its discretion when its decision exceeds the bound of reason or is arbitrary, capricious, patently absurd, or even whimsical. Put another way, a ruling that constitutes an abuse of discretion has been described as one that is so irrational or arbitrary that no reasonable person could agree with it. Peterson contends that the prosecutor's question to Meg regarding how she felt about coming into court today was improper, and that the trial court permitting it was inexplicable. Damn, they say he's wrong. They say Peterson is mistaken. They said, Tory, you're wrong. The court instructed the jury, as courts do in every criminal trial, on a non-exclusive list of 11 factors jurors may consider in judging the credibility or believability of the witnesses. One of those factors is, what was the witness's attitude about the case or about testifying? Other factors include, did the witness make a statement in the past that is inconsistent or consistent with his or her testimony? And did the witness admit to being truthful? Meg's credibility was a key issue in this case. Indeed, in cross-examination, Tory's counsel repeatedly asked Meg to admit she lied. Tory also asserts this testimony was irrelevant and prejudicial because it elicited sympathy for Meg. However, at the outset of the trial, the court instructed to the jury, your verdict must be based only on the evidence presented during the trial in court and the law as I provided to you. The court also told the jury, do not let bias, sympathy, prejudice, or public opinion influence your decision. And before closing arguments, the court again instructed the jurors, you must not let bias, sympathy, prejudice, or public opinion influence your assessment of the evidence or your decision. We presume that the jury understood and followed the court's instructions in reaching the verdict. So that's the first part. They say, Tory says, hey, I saw some problems with this, and we're raising it on appeal. Like, she even admitted to lying when my attorney was asking these questions. However, when you raise something on appeal, you have to look at what the parties have done. Did the judge make a mistake there? And in the Court of Appeals here, they're saying, no, the judge didn't make the mistake. So that's the first argument. All right. So we got one down, chat. Let's go to the next one and see what else they say. Evidence Code Section 352 does not apply retroactively, and the trial court did not abuse its discretion in admitting a photograph of Tory's torso and arms. Tory contends the trial court reversibly erred, so they made a mistake in admitting evidence of his creative expression, specifically a photograph that showed tattoos on his torso and arms. At trial, Officer Sandra Cabral testified she and her partner stopped a vehicle that matched the description of a vehicle in a radio call they received. 4 people, later identified as Tory, Meg, Harris, and Smith, were in the vehicle. An ambulance took Meg away, and Cabral and her partner arrested the other 3 and took them to Hollywood Station for further questioning. As the officers had found in the vehicle a handgun that was warm to the touch and in the slide lock position. When they got to the station, they tested Peterson, Harris, and Smith for gunshot residue. Let's go back up to this footnote up here. It says Meg's testimony about being hated on social media for having come forward also was relevant to her attitude about the case or about testifying. When asked what were some of the things that you were seeing and how did that affect how you felt about coming into court today, Meg said, Megan should have been shot and killed. I would have shot that itch too. That itch lying. Hoes always doing it like shit like this. Who cares? She fucked everybody. She should have been shot. So Megan was talking about some of the heat she was getting on the internet, and those are examples of it. That's what that footnote talks about. The prosecutors marked as exhibits 3 photographs taken at the station and depicted Tory, Harris, and Smith, respectively. In a photo marked as Exhibit 18, Tory appears to be wearing black shorts or swim trunks. He is shirtless, and the tattoos on his chest and arms were visible. In a photo marked as Exhibit 19, Harris appears to be wearing a black 2-piece swimsuit. Tattoos are visible on her arms and left thigh. In a photo marked as Exhibit 20, Smith appears to be wearing a black pants and a long-sleeve black top. At sidebar, Peterson's counsel objected to the photograph, arguing it was irrelevant and would only sway the jury because it looks like he's got tattoos. The court replied the photos were to show who the people are that she, Officer Cabral, took the swabs from. The court continued, I don't see anything wrong. This is the judge. He has no shirt on. He has tattoos. Other than that, what's wrong with the picture? At the conclusion of the evidence, the court discussed the exhibits with counsel. When the court asked defense counsel if he had any objection to the admission of the evidence of exhibits 18, 19, or 20, he replied, no, Your Honor. In support of his claim of reversible error, Peterson cites Evidence Code Section 3522. I'm not going through all that. The statute requires the trial courts to consider certain factors when a party seeks to admit as evidence a form of creative expression in any criminal proceeding. The statute defines creative expression as the expression or application of creativity or imagination in the production or arrangement of forms, sounds, words, movements, symbols, including but not limited to dance, music, performance art, visual art, poetry, literature, film, and other such objects. Peterson cites People versus Venable. The Court of Appeal had held the Evidence Code Section 3522 applies retroactively to cases that are not final yet. In his opening brief, Tory failed to note that our Supreme Court had granted review of Venable. Okay, so they cited some case law from 2023, and it looks like it was still in review at the time, some 9 months earlier. Tory also failed to cite either of the 2 cases that reached the opposite conclusion. So there were 2 cases that Tory's team missed. In his reply brief, Tory acknowledged the grant of review and mentioned Slayton, which is a newer one in 2023. Tory stated he relied on his previous argument pending a final outcome in the High Court. On August 28th of 2025, the Supreme Court held in Agari that Evidence Code Section 3522 does not apply retroactively. So this is interesting because, this precedent has been developed in 2023, and it was also happening after Tory got convicted. Agari involved rap lyrics and instant messages attributed to the defendant. Chief Justice Guerrero explained to the High Court having the language of Evidence Code Section 3552 and its uncodified legislative findings saw nothing that clearly and unavoidably reveals an intent to depart from the general rule of prospective only application, not retroactive. Accordingly, Section 3552 does not assist Tory. In any event, the record does not support Tory's contention that Exhibit 18 injected racial bias into the proceedings. Okay, Exhibit 18 is a picture of his tattoos. The prosecution did not offer the photograph as evidence of any alleged gang affiliation. There was no gang allegation in this case, and no one ever suggested that Tory had any gang ties. The prosecution offered the picture of the tattoos, and the court admitted them into evidence solely to show the identity of the individuals officers swabbed for gunshot residue at the police station. The record does not reflect whether Tory was wearing a shirt when police stopped his vehicle. Meg testified they just emerged from the swimming pool. She was wearing a bikini, and Harris was in a swimming pool too. Meg's stylist, Eric, called by the defense, also testified that both Meg and Kelsey were wearing swimsuits when they got into the SUV. Culberson also testified Tory was wearing drawers and they just left Kylie's house. In his closing argument, Peterson's counsel referred to Tory was wearing as his trunks. There was no testimony at trial that Tory had been wearing a shirt, and the officers asked him to remove it in order to swab his hands for gunshot residue or take his photograph. Tory asserts that the prosecution explicitly and improperly introduced racial bias into the proceedings by asking a witness about what appears to be a tattoo of a firearm in the middle of Tory's chest. Defense witness Culberson testified he was Meg's stylist and friend. He sometimes was Meg's driver as well. From the questioning, it appears the defense called Culberson to ask if Pete or Harris had a gun in their luggage. On direct examination, defense counsel also asked Culberson if he had ever seen Tory with a gun. Culberson replied no. Counsel asked if Peterson ran around with guns. Culberson answered no. Cross-examination, the prosecutor asked Culberson a series of questions about whether he'd ever seen Harris with a gun, Harris is Kelsey, and whether he'd seen Meg with a gun at any time that day or night. He did not ask Culberson if he had ever seen Tory with a gun. On redirect, defense counsel then asked Culberson if he had ever seen Tory with a gun. If he ever seen Tory have a bag that had some weapons with him, and whether he'd ever seen Tory discuss anything about guns. Culberson answered no to those questions. On recross examination, the prosecutor and Culberson had an exchange. Okay, prosecutor says, now, counsel asks you if you've ever seen Tory talk about guns or if you've ever seen him with guns. Do you recall that? Witness says yes. Do you ever see the big gun that Tory has tattooed on the center of his chest? Uh-oh. No, I haven't seen Tory's body. Defense counsel did not object to that question. In short, the record does not support Tory's contention that the prosecutor utilized Tory's tattoo, which is intertwined with the rapper's persona, to lead jurors to conclude he is a violent criminal with a predisposition to commit crimes. It was defense counsel who asked, so it was Tory's own team who asked, both on direct and on non-direct, if Culberson had ever seen Tory with a gun. Neither of those prosecutors ever mentioned Tory's tattoos, much less the tattoo of a firearm in their closing arguments. Tory also complains that Meg's testimony about a music video with Tory had released poisoned the proceedings by directing the jury to infer that if Tory was chopping up horse legs in a music video, he was violent enough to shoot her. Tory seems to be referring to Meg's answer to the prosecutor's question about whether she regretted having come forward. Meg said, if I would have known that coming out and speaking my truth would come with people agreeing with me being shot, if I had known, I would have started to lose my confidence, lose my friends, lose myself. I didn't ask for this. I didn't want to come out about it in the first place. I started to feel like, damn, maybe I should be dead. I got to watch Tory drop music videos chopping up horse legs and people laughing at it like that's okay. Defense counsel did not move to strike Meg's reference to the music video. Damn, this is not good. They're literally just pointing out the mistakes that Tory's defense team made. They had the opportunity to object and they didn't. They didn't object to that stuff. No such music video was offered into evidence or shown to the jury. In any event, Meg's brief reference to the video, which she took as directed at her or even as a threat, was permissible for the same reasons we've already discussed. It's relevant to Meg's attitude about the case or about testifying. So Tory lost that one too. Next, here's the next one. Here's the next big argument that Tory had. The trial court did not impermissibly chill Tory's right to testify. And as Tory did not testify, he cannot raise this issue on appeal. Damn. Damn it, Tory. Tory asserts the jury did not hear Tory's account regarding that night in question because the court ruled that if he testified, prosecutors could introduce his music video and rap lyrics during cross-examination. Tory mischaracterizes the record. Midway through the defense's case, the prosecutor told the court he was asking to inquire about prior acts of violence if Tory testified to rebut the character evidence put on by the defense. The court replied, well, I think the state of evidence is as is right now. I would not allow that. But of course, I don't know what he would say if he testifies. It may become relevant depending on what he were to say, but at this point, I will exclude that. The prosecutor listed a number of items with which he proposed to impeach Tory, including social media posts, rap lyrics, Instagram posts, a 2019 Miami incident, a 2022 incident with August Alsina, not August, and more. An incident with love and hip hop star Prince at a Florida nightclub. The court stated some of this would be admissible, those portions that pertain to this case. Some wouldn't. The court continued, the best I can tell you at this point is if your client testifies, I'll have to take it on a case-by-case basis. But essentially, anything pertinent to this case, obviously, is fair game. If it pertains to some other incident, maybe it is. Maybe it isn't. It depends. Let's look at this footnote. August Alsina is a singer-songwriter. The prosecution alleged that Tory, wearing heavy rings on his fingers, had punched Alsina without warning on September 17th in 2022 in Chicago, knocking him to the ground and bloodying him. Well, there you have it. Let's keep going. I mean, this is just getting good. This is actually a pretty interesting document. We're halfway through, guys, so we're almost done. To this, after the defense had called 7 witnesses, the following exchange took place. Judge says, Mr. Masaki, I don't even know how to pronounce that. You've advised me that your client has elected not to testify. All right, so he's saying to Tory's lawyer. Mr. Masaki says, that's correct, Your Honor. The judge says, so, Tory Lanez, you know you have the absolute right to testify if you choose. You have the absolute right not to testify if that is your decision. If you testify, you will take the stand and be questioned just like all the other witnesses were by both sides. If you choose not to testify, I will instruct the jury not to consider it or not to hold it against you. Do you understand what I'm telling you so far, Tory Lanez? Tory Lanez says, yes, Your Honor. The judge, have you had a chance to discuss that decision with your attorney? Tory Lanez, I have, Your Honor. The judge, and based on your discussion, is it your choice at this point not to testify? Tory Lanez, I will not testify. Neither Tory nor his counsel ever told the court that Tory wished to testify, but was deterred by the prospect of impeachment by the prosecution. So yeah, I gotta hold Tory to that a little bit, because if he were to testify, the judge is like, some of this stuff might come in and some of it won't. But Tory, I mean, the decision is on him. He chose not to do it. So it was his choice. Okay, they cite case law here, the loose case. The Supreme Court considered a case like this one in which a defendant did not testify, then argued on appeal that the court had abused its discretion in denying his motion in limine to preclude the prosecution from asking about a prior conviction. The court said, hey, a reviewing court is handicapped in any other effort to determine if a trial court preferred the necessary balancing because the conduct of that review. The court must know the precise nature of the defendant's testimony, which is unknowable when, as here, the defendant does not testify. In Lucy, as here, there was no commitment by the defendant that he would testify if his requests to exclude possible impeachment were granted, nor did he make a proffer to this court as to what his testimony would be. Moreover, a reviewing court cannot assume that the adverse ruling motivated the defendant's decision not to testify. And even if those difficulties can be surmounted, the reviewing court would still face the question of harmless error. The Supreme Court concluded the careful weighing of probative value and prejudicial effect required a trial court can only be evaluated adequately on appeal in the specific factual context of a trial as it unfolded. Some more case law there. The Lucy court's reasoning is directly on point here. Tory argues Lucy does not apply because that case involved possible impeachment with a prior criminal conviction. And two, that evidence code, that pesky one, 352, would have required the court to exclude all of the possible impeachment evidence. They said, Tory, we are not persuaded. Nothing in Lucy suggests its holding is limited to impeachment with a prior conviction as opposed to other types of conduct or acts. And as we have said, evidence code section 352 does not guide us in this appeal. So Tory lost that argument too. His next one. The mention of Tory's criminal case in Florida was not prejudicial. Oh. Did he have a criminal case in Florida, chat? Okay, let's see. Tory says inculpatory statements, which were inculpatory as to the shooter's identity, were improperly introduced in spite of their factual falsity. Tory apparently was referring to Meg's testimony that shortly after the shooting and when she and others heard police sirens, that Peterson offered her and Harris $1 million. Tory said, I can't go to jail. I already got caught with a gun before. Don't tell on me. A few questions later, the prosecutor asked Meg, what's he saying exactly? Meg said, I'll give y'all $1 million if you don't say nothing. I can't go to jail no more. I'm already on probation. In the defense case, Tory's counsel recalled the lead detective, Ryan Stogner. Counsel questioned Stogner about his interview of Meg after the shooting. Counsel asked if Meg had told him that Tory stated, please don't say anything because I'm on probation. Stogner began to answer, it was something to that. Then the prosecutor objected. The court overruled the objection. This exchange followed. Okay, prosecutor. Sir, did you do any investigation afterwards to find if my client, sorry, this is Tory's lawyer. Sir, did you do any investigation afterwards to find if my client was on probation at the time this case was happening in July of 2020? Answer, cop says yes. Was my client on probation, sir? Answer, cop says no, not to my best recollection, sir. After defense counsel asked Stogner about probation, the prosecutor began to ask a question about it. Defense counsel objected. At sidebar, the prosecutor told the court, Mr. Lanez was actually on a Florida-Miami probationary term that started in 2017. She added that even if that were not the case, defense counsel was accusing the victim of lying about what Tory had said. Defense counsel stated Tory got arrested in the Miami case, but was never charged. Outside of the jury's presence, the court and counsel discussed the matter at some length. The prosecutor told the court the defendant was ordered diversion for a gun possession in 2017. He released an Instagram live video where he talks about going to his probation officer. After more discussion, the court stated, I will allow you to inquire that there was an incident in 2017. He was placed on court diversion. Don't mention what the arrest was for, and we'll leave it at that. Later, defense counsel and the prosecutor stipulated to advise the jury that Peterson was ordered a grant of diversion for a criminal case in 2017, and that diversion was terminated in April of 2017. The court told the jury that the stipulation meant that there is a fact that is not in dispute in this case, and that they were to accept that is conclusively proven. Both counsel agreed to a special jury instruction about diversion. So this is all about Tory's case from 2017 in the probation, right? In accordance with that agreement, the court instructed the jury about the nature of diversion. The instruction stated diversion and probation are not the same. You are not to speculate about the circumstances of Tory Lanez's grant of diversion in 2017. It was terminated in 2017. And you are not to conclude from this evidence that Tory Lanez has a bad character or that he disposed to commit a crime. Thus, after the prosecution asked Meg about Tory's statements, defense counsel raised the issue of probation with the detective in an effort to show that Meg lied to the police. Meg's testimony that Tory said he had been caught with a gun before was not false. In any event, Tory's counsel reached an agreement with the prosecution to present a stipulation with the true facts to the jury and for the court to instruct the jury on what diversion means. The record does not support Tory's claim of error at this point. Guys, I mean, Tory's lawyers are making some mistakes. At least that's how this court is seeing it. You're complaining about the probation or the diversion, but y'all bought that up. Like, okay, oh my God. Let's keep going. So that's the fourth argument that Tory lost in this document. Let's keep going. The trial court did not err in permitting the prosecution to play for the jury as a prior inconsistent statement the recording of Kelsey's interview with prosecutors. Tory contends that the trial court reversibly erred, meaning they made a mistake, in permitting the prosecution to play for the jury its recorded interview with Kelsey Harris. Tory relies on the confrontation clause in Crawford 2004, and Tory is mistaken. The issue is one of inadmissibility under the evidence code. It does not involve the confrontation clause. Damn it. So Tory needs some new lawyers. The prosecution subpoenaed Harris to testify at trial. The court had appointed counsel for Harris, and the prosecution had granted her use immunity. This reminds me of Donna Adelson's case. Once on the stand, to say Harris was a reluctant witness is an understatement. Kelsey repeatedly claimed not to remember what had happened that early morning and in the days following the shooting. To question after question, Kelsey replied she didn't remember, couldn't remember, or didn't know. She repeatedly said it was a blur several times. Kelsey said she wanted to take the fifth. The court told her she had to answer the question. Kelsey repeatedly said, "I don't want to be here." In an attempt to refresh Kelsey's recollection, the prosecutor played excerpts of a recording of a September 14, 2022 interview. The two prosecutors had interviewed Kelsey in the presence of her husband and an investigator from the district attorney's office. Two attorneys representing Kelsey were present on the phone. Again and again at trial, Kelsey told the prosecutor she'd have to refresh her recollection with the recording. Confronting her with her prior inconsistent statements, Kelsey testified that there were some things she just wasn't being truthful about in her interview. Kelsey also testified she didn't remember telling prosecutors things that she can be heard saying in the recording. I wish I saw this trial. When asked if she had said in the interview that she had seen Peterson shooting through the window or at the top of the door, Kelsey replied, "Again, this is the night of alcohol. I don't know. In light of Kelsey's claimed failure to recall what she told the authorities and her testimony that she had been untruthful in some of her statements, the prosecutor proposed to play the recorded interview for the jury, citing evidence code sections 770 and 1235. The court said that they would allow it. 770 generally governs the admissibility of extrinsic evidence. blah, blah, blah. The statute requires that only the witness be given the opportunity at some point at trial to explain and deny the inconsistent statement. The other one, 1235, provides that evidence of a statement made by a witness is not made inadmissible by the hearsay rule if the statement is inconsistent with her testimony at the hearing and is offered in compliance with Section 770. Where the out-of-court statement is inconsistent with the witness's trial testimony, the jury might consider the prior statement for its truth as well as its light that it sheds on the witness's lack of credibility. Skip all that. So the prior statement has a dual purpose and may be considered for impeachment as well as substantive evidence. When a trial court concludes on substantial evidence that a witness's professed lapses of memories are false, not the false memory, evasive devices to avoid truthful answers, it may admit as inconsistent the witness's prior statements describing the events the witness has now claimed to have forgotten. Tory loses that argument too. That's 5. The whole thing. I mean, we're halfway through. Can this man get something? The next one. The trial court did not abuse its discretion in admitting evidence regarding an Instagram post. He lost this one too, dear Lord. Number 6. Tory contends the trial court reversibly erred in admitting an alleged inculpatory Instagram post, which was disclosed to the defense in an untimely fashion, amounting to the inadmissible hearsay and was highly prejudicial, thereby resulting into a manifest injustice. We don't agree. After the jurors were selected on a Thursday, the court excused them so it could discuss various issues with counsel before opening statements, which were scheduled to begin that Monday. During that discussion, the prosecutors told the trial court and defense counsel that they had just been made aware of a September 2020 Instagram post by the defendant in which he said a comment posted by someone else that Kelsey shot Meg was not true. The prosecutor gave that information on a CD to the defense counsel, who said that they'd take a look at it, but he thought that there might be a foundation issue. The following Tuesday, the prosecutor filed a motion to admit the defendant's statement on Instagram. The prosecution attached to its motion a photograph of a post by Little Jew made the beat. That is the Instagram user that left this comment. And the comment said, "This goofy ass ninja say he ain't shoot her, and they literally have matched the bullets from the gun to the ones in her foot." Below this statement, liked by Frosted Cupcake and 281,000 other people, right? The statement by the Shade Room says hashtag Megan Thee Stallion's producer alleges that authorities have matched the bullets from Tory Lanez's gun to the one found in her foot. Under that, view all by 13,000 people and more comments. Next, Spliff K says, people saying Kelsey shot her, crying emoji. Finally, a post by Tory Lanez to Spliff K says, that's not true. The date on the post is September 25th, 2020. Tory, what the hell? Tory. 2 days later, the court discussed the Instagram post with counsel, citing People versus Valdez. If the people established a requisite foundation, namely that this account is linked to a certain individual, that goes more to the weight of the evidence than the admissibility. Detective Ebhart then testified. Ebhart stated he had clicked on the Tory Lanez hyperlink, and that directed him to an Instagram page where the username was Tory Lanez. You just breadcrumbed them to you. Okay, I'm just looking at the footnotes. The prosecution X'd out 3 letters in the post. 9, only portions of the Lee opinion were published. The part discussing the admissibility of Facebook and Instagram post was not in the published version. Okay, that's fine. Let's keep going. On cross-examination, when asked, do public figures have people who run their Instagrams? Ebhart replied, that's fair to say, yes. Ebhart testified he never said that Tory made the post, adding he could only testify to the username of the account that the post came from. Ebhard stated he did not know who was controlling Tory's account. Defense counsel marked it as Exhibit E and showed to Ebhard an Instagram post apparently from the user Mid Jordan, replying to Messiah Carey. These names. The post states, "This is not real. Y'all want to believe anything. I'm the only person with access to Tory's account at the moment." Defense counsel noted the post had been liked by Tory Lanez. Ebhard testified he never seen the post. So what do y'all think? Like, is that post indicative of guilt here? Because what does the post say? Whoever wrote back or liked it, whoever that was, whether it was somebody from Tory's team or Tory himself, somebody said, "Kelsey shot Meg," and the Tory account says, "That's not true." I mean, it's just, I'm seeing a lot of mistakes here. I don't know. You guys let me know what you think about this in the chat. I mean, shout out to Buddy305. It was like, Tory's a victim of his own doing. Just like the YN. Stay off social media when you're caught up. I mean, you know, Trainwreck says, been with me for 16 months, says Meg wanted him to lose his deal. Kelsey shot her. Yeah, there's a lot of rumblings about this one, but let's keep going and see what the appeals court says here. When the time came to discuss with counsel the admission of the exhibits, defense counsel said he objected to Exhibit 40A, the Instagram post, Exhibit 40B, photographs on the account on Foundation. The court admitted the exhibits over the counsel's objection. Defense counsel moved to the admission of Exhibit E. The court stated it wasn't sure if any foundation was laid. The prosecution objected on the ground that the court sustained the objection. The court noted the exhibit's exclusion did not preclude defense counsel from arguing that any post would have come from other people other than Tory, and counsel did so. On appeal, Tory complains of late discovery. Counsel never made this objection during trial. Oh my God. He did not ask for a continuance, exclusion of the exhibit as a discovery sanction, or jury instruction. It was not until Tory filed this motion for a new trial that he first raised the issue. Tory has forfeited the timeliness issue on appeal. Tory also asserts the Instagram posts are inadmissible hearsay. The trial court's ruling on inadmissibility of evidence, including the hearsay nature of the evidence in question, is reviewed for abuse of discretion. We do not reach the question of any abuse of discretion here because Tory did not object to the exhibit's admission on this ground at trial. He raised it for the first time in his new trial motion. Peterson's failure to object to the post as hearsay at trial also forfeits that argument on appeal. Jeez. Okay, what's this down here? Tory filed a declaration of Joshua Farias with his motion. Farias declared he was the manager of Tory's Instagram account, and he was the person who replied to Spliff K. Farias declared, I never consulted with Tory Lanez in posting that comment on September 25th. And ruling on Peterson's new trial motion, the trial court stated that Farias' declaration was not newly discovered evidence. The court continued, I think that's something that could have been discovered through reasonable means. That is funny. So Tory ended up getting somebody to... So Tory got his manager to come to court or sign an affidavit or something declaring that he is the one that replied to that, right? That it wasn't Tory. The court's still like, you still lose. I mean, you still lose because you forfeited that. It should have been brought up on during trial. And you're bringing it up now on appeal. There's so much about this that has to be done in a timely manner. But this is the issue when you have one lawyer do your trial and then you have another lawyer take over for appeal. Because the ones that take over for appeal, they're going to pick out all these things, all these arguments, all these mistakes. But if you weren't there to object during the time of, and that other person didn't, yeah, you're in a pickle. You're in a pickle. You really are. But let's keep going. Finally, an error in admitting the Instagram post was harmless. Oh no. As the trial court noted, the Instagram post was an extremely minor issue in the case. The case turned on Meg's testimony, Tory's admissions to Harris when he called her from jail, and other similar evidence. Detective Ebhart testified he was not saying that Tory had posted the statement. That's not true. And he admitted that he had no knowledge of who controlled Tory's Instagram account. So that was number 6. Number 7. The trial court properly instructed the jury on count 1 and the firearm enhancement. Any error in the instructions on count 2 was harmless. Damn, they're clobbering him in this. So they are agreeing with him in this argument here for number 7, that they're like, okay, there was an error, but it was harmless. I would be so mad if I was Tory right now. Tory contends the trial court reversibly erred in its instructions to the jury on counts 1 and 2. Count 1, alleged assault with a semi-automatic firearm in violation of Section 245, Subdivision B, and count 2, alleged having a concealed unregistered firearm in a vehicle in violation of blah, blah, blah. In count 1, the people also alleged that Peterson personally used a firearm in the commission of the offense within the meaning of 122.5, right? At the conference on jury instructions, the trial court told counsel it would give Cal Crim 250, the union of act and intent, general intent. The court continued, so all 3 crimes here are general intent crimes. Defense counsel did not agree or object. Again, Tory's argument on appeal is somewhat difficult to understand. He asserts assault with a semi-automatic firearm is a general intent crime, yet the enhancement attached to this count through the Penal Code Section 120.22.5 requires specific intent. Jesus Christ. Oh my God. Okay, in criminal law, he need to get Brian Steele. In criminal law, you take crimes and you break them into 2 categories. General intent, specific intent, right? It really boils down to the mens rea with these crimes. General intent crimes are like, they're very basic, specific intent crimes. They go into like this level of specific intent that you need, right? Those are the more complex crimes. You learn this, I swear to God, in your first semester of law school. I don't know who wrote this, but your first semester of law school. That was a rookie mistake. Peterson does not cite any case in support of this contention. No case has held that assault with a semi-automatic firearm or personal use of firearm enhancement requires specific intent. Oh, now they broke it down for him. To prove assault with a firearm, the prosecution must prove 1, the defendant did act with a firearm that by its nature would directly and probably result within the application of the force to a person. 2, the defendant did that act willfully. 3, when the defendant acted, he was aware of facts that would lead to a reasonable person to realize that his act by its nature would directly and probably result in the application of force to someone. And 4, when the defendant acted, he had the present ability to apply force with a firearm to a person. Those are the elements of that crime. Thus, this instruction requires a defendant to have acted willfully and with an awareness of facts that a reasonable person would recognize would result into the application of force to a person. The jury instruction defines willfully as someone commits an act willfully when he does it willingly or on purpose, as opposed to, for example, to accidentally. The word willfully implies someone simply a purpose or willingness to commit the act. It does not require any intent to violate law, to injure another, or to require any advantage. So they start going into the words willingly, willfully. Similarly, the jury instruction for the personal firearm use enhancement requires only that the defendant personally used a firearm during the commission of the defense. Tory's contention regarding count 2 requires more discussion. Tory asserts likewise count 2 is a specific intent crime and required instruction. That instruction is entitled general and specific intent together. To prove the offense of carrying a concealed firearm within a vehicle, the prosecution must prove, here are the elements. 1, the defendant carried within a vehicle a firearm capable of being concealed on the person. 2, the defendant knew the firearm was in the vehicle. 3, the firearm was substantially concealed within the vehicle. And 4, the vehicle was under the defendant's control or direction. Knowledge is not the same thing as specific intent. Damn, they're beating him up here. The word knowing, as used in a criminal statute, imports only an awareness of the facts which bring prescribed act within the terms of the statute. However, knowledge is a required mental state for a violation of the statute. For the first time in his reply brief, Tory cites the bench note to Cal Crim number 250. The note states, this instruction must not be used if the crime requires a specific mental state, such as knowledge, even if the crime is classified as a general intent offense. If the case involves both offenses requiring a specific intent or a mental state and offenses do not, the court may give Cal Crim 252 in place of this instruction. We review the adequacy of the instruction and independently from the bench note that Cal Crim 250, it appears the trial court should have given the instruction. Okay, all right, Tory, we got something. Listing assault with a semi-automatic firearm and the firearm enhancement as requiring only general criminal intent, but listing carrying a concealed firearm within a knowledge as requiring the specific mental state of knowledge. However, oh no, on this record, the court's failure to do so was so harmless. Oh, so Tory got something with that one on count 2. However, on this record, the court's failure to do so was harmless. In reviewing a claim of instructional error, the court must consider whether there was a reasonable likelihood that the trial court's instructions caused the jury to misapply the law in violation of the Constitution. We review the challenge instruction in the context of the instructions as a whole and the court record to determine whether there is a reasonable likelihood that the jury applied the instruction in an impermissible manner. The trial court did instruct the jury that the prosecution was required to prove not only that Tory committed the prohibited act, but that he did so with wrongful intent and that he knew the firearm was in the vehicle. In closing, the prosecutor argued Tory knew it, that the gun was there. Of course he did. He grabbed it. He shot Megan with it. Defense counsel told the jurors, my client didn't even know the gun was there. Uh-oh. Counsel said Tory jumps in the seat after the girls are in the car. Counsel continued, they're trying to say my client knows the gun was there and he touched the gun and he put the gun there. Why then, counsel asked, was his DNA not found on the gun? In short, the jurors were all aware that the prosecution had to prove Tory knew the gun was in the vehicle. Jurors are presumed to be intelligent and capable of understanding and applying the court's instruction. Reversal on count 2 is not required. I mean, I don't think Tory had a good lawyer. Any ambiguity in Cal Crim is harmless in this case. On the allegations that in committing the offenses of counts 1 and 3, Tory personally inflicted great bodily injury on Meg, the court instructed the jury with Cal Crim 3160. That instruction states great bodily injury means significant or substantial physical injury. It is an injury that is greater than minor or moderate harm. Peterson cites a bench note following the instruction that cautions court, this sentence of the great bodily injury definition could result in error if the prosecution improperly argues great bodily injury may be shown by greater than minor injury alone. All right, let's keep going. Any ambiguity in this definition is harmless, and in this case, because substantial evidence established beyond a reasonable doubt that the injuries Peterson inflicted on Meg were more than moderate harm. Indeed, they were more properly categorized as significant or substantial harm. Megan had to get surgery to remove the bullet fragments in both feet. She had a lot of pain and couldn't walk for a while. Megan had physical therapy for a few months. She had an orthopedic surgeon who operated on her foot testify at trial, and the jury saw accurate x-rays of Megan's feet and a report of the operation. The surgeon told the jury Meg was placed under general anesthesia for the surgery. The surgeon described in details the steps the team of 3 surgeons took to remove the questionable tissue and the metal fragments, flush the areas, and close the wounds with sutures. Meg was admitted to the hospital after the surgery. This testimony was more than sufficient to support the jury's finding that Tory personally inflicted great bodily injury to Meg. Okay, let's keep going. So he lost that too. The prosecutor's statements and closing argument do not require reversal. So it looks like that was one of his arguments, that it should be required because of what was said in closing. Peterson contends the prosecution engaged in prosecutorial misconduct in making improper comments during closing argument. According to Tory, these improper comments consisted of improper appeals to emotion and sympathy for the victim, arguing facts not in evidence, and disparaging defense counsel. Tory implicitly acknowledges trial counsel did not object to any of the statements of which he now complains of. So he's acknowledging again, like, my people did not object properly. That's the thing. They're not objecting. Tory cites a case for the proposition that this forfeiture rule does not apply if an admonition would not have cured the harm. But he does not explain how admonitions here would not have cured any harm from the prosecution's statements. In any event, Tory's claims of misconduct fail on the merits. A prosecutor's conduct violates the 14th Amendment to the federal Constitution when it inflicts the trial with such unfairness to make the conviction of denial due process. They're citing some case law, so I'm going to skip all that. As we have explained, the prosecution's questioning of Megan about why she initially lied to medical professional and police, the criticism directed at her after she accused Tory, and her attitude about the case and about testifying was not improper. Reference to that testimony in closing arguments was not improper for the same reason. As for the prosecutor's reference in his opening statement to what he expected Justin Edison to say if he testified, it is not uncommon for counsel on both sides to tell the jury that a particular witness will testify, only to be unable ultimately to procure that witness's appearance. With respect to the prosecutor's suggestion that Tory tried to bribe Kelsey and his question, where is Justin, right? Meg testified, Tory said, don't tell on me, and I'll give y'all $1 million if you don't tell on me, immediately after the shooting. Kelsey said the same thing in her September interview with the prosecutors. Though by the time of the trial, 3 months later, she equivocally about why Tory offered her the money. Kelsey also told prosecutors she met with Tory outside a hotel a day or two after the shooting, and he asked her if she needed a job and if she wanted to work with him. He also mentioned investing into a business. Prosecutors may argue inferences from the evidence. When attacking the prosecutor's remarks to the jury, the defendant must show that the context of the whole argument in the instructions, that there was a reasonable likelihood that the jury understood or applied the complained of comments in the improper or erroneous manner. Tory has not made that showing here. Damn it. Finally, regarding Tory's assertion that prosecutors repeatedly throughout the closing arguments, this trial was vigorously litigated and hard fought. Both sides accused the other of misleading the jury. Defense counsel told the jury the prosecution's case was full of holes, and the prosecutors had the audacity to ask jurors to speculate. Counsel asked why the prosecution hadn't called Sean Kelly as a witness or the investigating officer, Detective Stogner. Counsel queried the prosecutor had objected to Kelly's testimony. Because they didn't want you to know the truth? Counsel asked, where was Jaquan Smith? And why didn't they call him? That's what his lawyer was saying. Referring to himself, defense counsel asked the jury, who told you the truth from the first day when I got up here and gave my opening statement? Counsel said, from the opening statement. Oh, this is what he said. We had a lengthy discussion when I was informed of this over lunch with my client, my associate, and my investigator. We came to the conclusion that we're not going to call him because obviously his testimony is going to be putting the gun in the hands of Kelsey. And that's what he told all of us when he just did an interview upstairs. At this point, my position was that the jury believes our theory. I think Sean Kelly already put the gun in Kelsey's hand. And if they're going to believe that he took the gun from him and you start to shoot it yourself, to me, it's a kind of absurd argument. Adding another person to say who has some connections to you as a security or a friend isn't going to do anything. So we decided we're not going to call him this morning. I told the prosecution we won't call him. Just move forward into the argument. I'm ready. They're ready. Let's just argue and instruct and be done with this. Jesus Christ. It's a lawyer. Defense counsel explained further at the reasoning of that, Your Honor, it's obvious with the holidays coming, my fear is I'll lose this witness. This witness made it very clear he's not going to stay here. Secondly, and more importantly, I think we're going to have a mistrial and we're going to lose jurors. The court asked, and you talk to your client or do you need to speak further to him? Counsel replied, I've spoken to my client. If the trial continues another 7 days, we'll have a mistrial. My client definitely doesn't want that. My client wants closure on this. He and his family are flying back out to Canada, and he wants to finish this. To every evidence they've introduced, ladies and gentlemen, they've tried to mislead you. In sum, none of the prosecutor's statements constituted deceptive or reprehensible methods that were reasonably likely to have affected the outcome of the proceeding. I mean, I'm seeing more and more of it. He's losing all these arguments, but we're finding the mistakes that Tory's lawyer made during the trial. Like 2 more pages, guys. The record does not support Peterson's contention that prosecutors' misconduct interfered with his right to conflict-free counsel. Tory retained Sean Capman Hawley to represent him in this case. Hawley represented Tory through the preliminary hearing as well as the extensive pretrial proceedings. According to Hawley, the trial expected to begin in late November and December of 2022. Tory wanted to add another lawyer to the team. In September of 2022, Hawley explained to Brian Gott, who appears to have been Tory's business manager, Tory has known him for a long time and trusts him. Hawley was engaged in an arbitration out of state that began in May of 2022. It did not conclude until December 16th of 2022, nearly 2 weeks after the trial commenced. In a letter dated January of 2023, the court said Hawley referred to this other engagement and explained, Tory understood and agreed that George would represent him at trial and that I would not. Oh, Tory, that's what happened. You had a stand-in lawyer. Oh, you can't make it up. You can't make it up. An email Peterson attached to one of his pleadings in connection with this motion for a new trial reflects a second reason Hawley did not represent Tory at trial. And the email dated November 21st to Tory with an email or a copy to the stand-in lawyer, Hawley stated she was not comfortable advancing a defense theory that it was Kelsey Harris and not Tory who shot Meg. In Hawley's view, it was not a viable strategy. Hawley recommended that Tory discuss this with his stand-in lawyer and his willingness and ability to move forward with that defense. On record again, an email Tory filed in the trial court reflects a third issue. Oh, Jesus. On December 18th, Hawley emailed Tory to let him know that she was going to file a motion to withdraw as one of his attorneys of record. Hawley stated evidence had been elicited during Kelsey's testimony that Hawley was somehow involved in facilitating an arrangement between Kelsey and Tory, whereby Tory would finance Kelsey's business or something like that in order to curry favor with her, thereby aligning your and her interests as far as the case was concerned. Hawley continued, you and I both know that this never happened. Hawley added she did not know whether Tory actually made such a statement to Kelsey and whether Kelsey made this up herself. Hawley stated, all I do know, look at that caps, all I do know is that this did not happen, nor would it ever happen. Hawley explained, in any event, the fact that these false allegations have been made about me and that they are now evidence in the case makes it a conflict, so she withdrew from his case. For me to continue to represent you, and as a result, I am obligated to withdraw as your attorney without any citation of record. Tory asserts, despite practitioners' plain knowledge that Hawley was not involved in the alleged bribery of Kelsey months earlier, prosecutors opted to wait until the mid-trial to raise the exact same allegations, relying on nothing more than Kelsey's same inconsistent statements dating back to September 2022. Tory claims these allegations left Holly with no choice but to disengage fully, lest her presence harm her client. Tory's wholesale failure. Damn, I've never heard that before. Tory's wholesale failure to support any of these assertions with citations to the record is telling. The letter and emails Tory himself attached to his new trial motion show the reasons why Holly did not try the case and ultimately withdrew. 1, she was engaged in a lengthy 7-month arbitration. 2, she was not comfortable with the defense blaming Kelsey for the shooting. 3, after Kelsey's statements were introduced at trial, she concluded she had a conflict. Nothing in the record supports Tory's allegations that the prosecutors opted to lull Holly into a false sense of security by deceptively assuring her that they did not believe her to be involved. The trial court, he lost that. The trial court did not err in imposing the midterm. Peterson contends the trial court reversibly erred in declining to impose a lowest possible term. Peterson's sole claim of error to this point is that the court found true the aggravating factor that the victim was particularly vulnerable within the meaning of Rule 4.421. There was some discussion in the trial court about whether Peterson qualified for the low term, so a lower sentence. That section provides, unless the court finds the aggravating circumstances outweigh the mitigating circumstances, that imposition the lower term would be contrary to the interests of justice. The court shall order imposition of the lower term if any of the following was a contributing factor to the commission of the offense. The person has experienced physiological, physical, or childhood trauma, including but not limited to abuse, neglect, exploitation, or SA. The person is a youth or was a youth, things of that nature, as defined in the subdivision. Okay. The court found that to not be true. That's a very long footnote. The trial court found 4 factors in aggravation: that Tory used a weapon in the commission of the crime, that the victim was particularly vulnerable, Tory's conduct towards the victim after the shooting before the time of the crime in the trial nearly 2.5 years later, and the fact that the court could have sentenced Tory to consecutive time on count 2, having a concealed unregistered firearm in the vehicle. The court found those 3 factors in mitigation. Tory had no prior record. Tory had actively participated in charitable and philanthropic causes, and that Tory had a low likelihood of reoffending. The court noted the balancing of the aggravating factors and were not a mathematical calculation. The court did not place great weight with respect to the aggravating factor. Okay, so he's basically saying, why did y'all give me all this time? And they're explaining why they were actually quite, or at least the trial court was actually quite fair in that time. Okay. I'm just scrolling here because they are saying that they don't find any error. This is that last argument. And yeah, here's the very last one. No ineffective assistance of counsel or cumulative error. As we find no ineffective assistance of counsel or prejudicial trial court error, we also find no cumulative error. We affirm Daystar Peterson's, Tory Lanez, his conviction. Not to be published in the official reports, but I got it for y'all. Boom. I learned a lot. I mean, did you? I didn't know that he had a first lawyer, but then, he's complaining about all these things on appeal, but it's because you had the stand-in lawyer who actually took you to trial. The stand-in lawyer wanted to blame it on Kelsey. The stand-in lawyer had all these theories. The stand-in lawyer made all these mistakes. What did we count? Like 9 or 10 of them? The stand-in lawyer. Your actual lawyer wanted to get off. This is reminding me a lot about a conversation I had about one Miss Alicia Andrews. She had an original lawyer who this is almost identical to what happened. We're going to talk about it. But Chad, this is a lot. Shout out to Trainwreck Entertainment, who gifted 5 AV memberships. I appreciate you, Trainwreck. If you received that, I hope you said thank you in the moment, because that document just sent to me. Like, I'm gonna have to go make an old fashioned after reading that. Shout out to Buddy 305 Love with the 5 says, so what the appeal court is saying is that Tory would have won with the good that's what, Buddy. Yeah, because there were valid points there. Because if somebody else wrote that appeal, it was a new lawyer, and they're like, hey, you're right, you're right. But he didn't object. That person didn't object. There was no objections. How can we review if there were no objections? Get some good attorneys, guys. Always keep that in mind. Shout out to Senator with the 5 says AV. Senator, good to see you. Good to see you. All right, guys. Y'all are like, man, he ain't getting out. I mean, that's the thing. But you know, it's so wild. And this is why sometimes with these trials, I want to watch it. Because had the public really known that Tory didn't have a good team, we would have all seen that. But because we didn't see it, you don't find out until appeals are filed, until these documents. This was filed 2 years ago, and they're just now getting a decision now. It's crazy. It is crazy. Well, anywho, guys, this I only wanted to go for an hour. It's been an hour and 40 minutes. I am going to get to bed. The schedule for tomorrow is we're standing by. Again, I'm not holding my breath. I heard that Fonnie Willis is not going to be attending the hearing tomorrow due to a scheduling conflict. That, again, we'll see. But we'll see what happens with the hearing. Other than that, we've got a lot of legal news coming out. So there's so much content. Just make sure you hit the like button. Make sure that you are subscribed, hit the bell, all of that stuff so you don't miss anything. And you will know when we are live streaming again. On Saturday, I'm debating, but I might do the trial that we missed last week. I might be able to get it done in a day because it is very short. So there's another trial that we might be looking at on Saturday or Sunday. That being said, I am going to get up out of here. Let me know what you guys think about this crazy appeal. I'll separate them out into the arguments if you just want to skip around, go into some chapters, all that fun stuff. Until the next time, my friends, stay safe out there. See you in the next one. Bye.